you're here right now, whether you're watching this after the fact or watching it right now. I am a self-represented litigant, pro per, sui juris, pro se, whatever you want to call it. Um, I've heard a lot of people use different terminology and they swear that it changes the outcome. I strongly disagree. Whether you call yourself sui juris, pro se, or pro per, um, I've yet to see that really have a genuine impact. So call it what you will. What I have before you is a writ of habeas corpus to the California Supreme Court relative to a violation of due process in the county of Napa. On 12/18/2024, a declaration of doubt was improperly asserted by an attorney named Kendall Barron in the county of Napa. It appears to myself as well as other individuals who have been subjected to this potential abuse of due process, um, that in the county of Napa, attorneys from the public defender's office are abusing a what's known as a PC 1368, Penal Code 1368, which is a declaration of doubt. It's an assertion there's been a significant breakdown of communication between the litigant and the attorney, or that the litigant is unable to understand the fundamentals or the proceedings, schizophrenia, insanity, things of that nature. This is a very serious action, and it is mandatory that sufficient evidence, not just any evidence, not just I feel, not I want, I feel my client is not mentally competent. I don't like what my client is doing. I've had arguments with my client. That's not sufficient. Um, that must be filed, evidence, supporting evidence and documentation, significant. See, there's very specific words when it comes to things like the PC 1368. There's must and shalls, and there's safeguards by the terminology in the statutory language of the law. Things like must, significant, so it can't just be, oh, I'm putting some documentation forward. It has to be significant evidence that goes into the record. The doubt has to be declared. It has to be spoken into the record. And what's happening, a further assurance of a denial of due process, is that these attorneys are seeking a sidebar, which is off the record. And we have transcripts, official transcripts allocated by the court, um, and further evidence that these attorneys are seeking a sidebar and often achieving a sidebar where they're declaring their doubt without any substantial supporting significant documentation. They are not speaking into the record. And how this denies due process for a litigant is that should that litigant need to appeal that action, there would be no explanation, no statement of decision or reasons for the appellate court to ascertain whether there was an abuse of discretion or a violation of this litigant's due process rights. I'm not an attorney. I am unfortunately a litigant, self-represented in federal court, California court, um, and federal court in the Eastern District of Virginia and in the Fourth Circuit Court of Appeals, and in Washington, D.C. Now, an attorney by the name of San Nguyen, we're going to read you those transcripts that we have, not today, where you can see San Nguyen went to sidebar with Judge Mark Bosnecker and stated and declared a doubt on at sidebar. And as a result of his action violating a man's due process rights, that individual was forced into what's known as Napa State Hospital. Other litigants have been subjected to the same outcome by the same arbiter and other arbiters in the county of Napa who are willfully intentionally discharging this due process violation against litigants. It has been turned into a weapon where it was established as a protection measure and a guardrail to ensure due process and to ensure that the machinery of justice is preserved so that people who are not mentally competent are not put on trial and subjected to something that they don't understand, and that alternatives can be introduced. Case in point, right now, we have a national case going on where the young lady was dispatched on the subway, and that individual was determined to be not competent to stand trial. It's cases like that where these are protection measures for people who may genuinely be ineffective at their own defense. And what's happening in the county of Napa by these individuals and these judges who know these rules. Judge Mark Bosenecker has had his rulings overturned for violating due process. For example, refusing to allow a man to um, separate from his attorney, which would be a Marsden motion. On 12/18/2024, I had made that request. And at a closed door hearing for a Marsden motion, Judge Mark Bosenecker made the ruling that there was not sufficient evidence to support a significant breakdown between the attorney and myself. So therefore, he marked off that as being an option for the what was to come being this declaration of doubt by Kendall Barron, because there can only be one or the other, either a significant breakdown between the client and the attorney, which he refused and denied the Marsden motion, saying that that was not the case, and then immediately opened up into another proceeding where that attorney would then declare a doubt, violating my due process rights and seeking a sidebar. And Judge Mark Bosenecker said, "Nah, we don't even need to do that." But in other proceedings, he has allowed attorneys to seek a sidebar and then pursue a doubt and not speak it into the record. And what this does is this means that you, as a litigant, have no rights. That means they can force medicate you, they can force you into an institution. They can then plead guilty on your behalf and accept anything. It's an extremely powerful thing, and that's why it should not be abused as they are doing in the county of Napa. This includes the Napa County District Attorney. This includes the judges that have discharged this. This is not one case. This is not a one-off. This has happened a myriad of times against multiple litigants. And some of you may have heard of what's called the vexatious litigant, and some of you know that it's also supposed to be a protection measure, but it has been turned into a weapon. It's been a rock that's supposed to break a window so if somebody could, metaphorically, escape a fire, and has been sharpened down into a spearhead and became a weapon when the people who are officers of the court, when they don't want to deal with somebody, or if somebody stands in opposition to their violating the rights of this litigant, they then turn these weapons against that person to overpower due process. But in order to discharge those, they are violating the must and shalls, the mandates of the statutory language of those laws. For example, Family Code 2030, pendente lite, controlling precedent would be in remarriage of Knox. They are violating the statutory language of that law and recreating and legislating from the bench their own versions of codified law. It's a violation of an act of Congress in some certain circumstances for things like California Evidence 1041. It's a violation of an act of Congress. It's a must, a shall, and they're deviating from it. Family Code 2030, they removed the judicial discretion, and I believe in 2011, where arbiters had discretion relative to needs-based attorney's fees, but the legislative intent changed that and removed discretion under certain factors. When certain factors are present, as a means to preserve justice and parity in lieu of disparity. So they wanted cases to be resolved on the merits, not on who had more money. So they removed the discretion of the arbiters relative to what's known as needs-based attorney's fees, also called pendente lite. And so if one party makes considerably more than the other, if there is a disparity of the income and the person makes the request to assert the right, there's a FL 150, an income and expense declaration that is submitted, and a request for order that initiates the mandate. And so the court must and shall rule on whether attorney's fees and how much are appropriate. There must be a disparity of income, and available funds. But they do have the ability to make people go get loans if one party, because you can imagine if somebody's disabled and say it's a couple and one is not disabled and they go to work and they make all the money, or they met and one party had a degree and the other party didn't, and one was given a responsibility to like take care of the children or whatever, or maybe that person's disabled and has a fixed income. So would it be fair for that person not to have an equal shake at the law or to have equitable justice? So therefore, they must use the 2030 pendiente lite to make disparity parity, right? They want fairness and equal justice. So that's not what's happening. We have written proof that judges in the county of Napa have violated 2030. And the controlling precedent for that is In Re Marriage of Knox 2022, where a young lady was made to go through a trial. She asserted 2030 early in the proceedings, and the expectation and ruling of the court was that she should weather a trial as an unprofessional attorney against somebody who had representation by attorney, just like my case, and she made mistakes that an attorney would not. Therefore, the court overturned that ruling. In Re Marriage of Knox 2022. That's the controlling precedent in California. I think it was the fifth. It was the fifth. I think it was the fifth Court of Appeals. So things like, you can imagine if the ADA is must and shall, and if Family Code 2030 pendiente lite is must and shall, and things like 1041 through 1043 California evidence codes are must and shall, in-camera review are must and shall, and jurisdiction is a must and shall. Family court is family court, criminal court is criminal court. So to willfully, intentionally abuse family court to segue over into criminal court as a means to seize control of a litigant, and then when the litigant stands for themselves, they then abuse the PC 1368, which is another must and shall. And on 12/18, Mark Bosnecker, Kendall Barron, and Laura Noga all violated PC 1368. Then they rotated it over to L.A. Ortiz, who further violated PC 1368. So this is a writ of habeas corpus to the California Supreme Court. And what the assertion is, matter of fact, I have the transcripts right here. I have not only the transcripts from, let me show you something. So let's talk about jurisdiction, right? Jurisdiction. So what this is that violation. This is a criminal complaint by Allison Haley, the Napa County District Attorney. Now it says right here, on or about February the 29th of 2024 in the county of Napa, state of California, the crime of disobeying domestic relations court order in violation of section 273.6A of the Penal Code, a misdemeanor, was committed by such and such, who did knowingly and intentionally violate a court order obtained pursuant to section 6200 of the Family Code of the state of California, to wit, temporary restraining order case number 24 FL 000144. Now, why that's significant? You heard that, right? 24 FL. And it said temporary restraining order. So it said FL, family law, temporary restraining order. And it also said who did knowingly and intentionally. That's mens rea, the guilty mind. Mens rea must be established. And that's why the Counterman versus Colorado arguments at the Supreme Court is so important. I humbly ask, go to YouTube, watch the Counterman versus Colorado argument. Listen to Justice Sotomayor where she, and Chief Justice Roberts and the others, where they explained they're concerned that these lower burdens of proof are being used to segue and have a chilling effect on people's rights, for people just speaking ambiguously. one of the justices said, I can't say that I've never said something like this. Because some people will say that, man, my kid better not be late for this, or I'm gonna, but they're not really gonna do that. They're just speaking ambiguously. But none of that was even said in the circumstance. But mens rea, Justice Sotomayor said that they're using these civil things to segue into criminal, where criminal you would have to prove mens rea, and these lower burdens of proof are being abused. They're building a house on a bed of sand, solid house, bed of sand. And so I want to read you the report from 229. Where's this at? Okay, so on 2/29/2023, 2018 hours, suspect sent V a text message regarding banking information, violating a served DVR restraining order 24FL000144. Suspect is prohibited from contacting victim unless it is brief, peaceful contact to communicate about the children for court order visitation. Officers were unable to contact suspect for statement. Victim requested prosecution. That's Pablo Lopez, Officer Pablo Lopez, right? Now, you heard I didn't speak to him. He was unable to contact me. I was driving for Uber. On 3/4/2024, suspect, me, that's what it says, who is the restrained party in a served DV criminal protective order, violated the court order. The protected stated suspect violated the order by sending her a text message around 12:44. Suspect was called and admitted to texting the protected person, and also stated he was confused by the order and thought he could ask her questions regarding legal things as they were going through a divorce. Now, the body camera footage would make it much more clear. I thought I was under a court order because the alleged victim had requested the court to order me to contact her for any new purchases. And so when that happened and something went wrong, I was under the impression I was mandated by the court. I made the same request. The other person agreed to that. That person requested to the court to order me to do so. So I'm not an attorney. I'm not represented. The other person is. Do you see the conflict right there? Again, what is that? That's also relative to the mens rea, man. And that would be, so let me continue. I digress. The message was a question regarding a payment on the vehicle. Due to the fact suspect contacted the protected person, there is probable cause to arrest for violating terms of a served DV criminal protective order. So they're saying that it was a CPO when it wasn't. You can see it right here. FL 24FL, family law. So those are two different jurisdictions. So in family law, if there's an allegation of a violation, they should have had contempt proceedings. They never did. Additionally, you know what the irony of this is? You know when this was filed, supposedly? 9/12. But in reality, it was 8/20 August, dated August 15th. And there's something about the 21st on here. That's interesting. August 22nd, right? So where was I in August? So that's 6 months later. Where was I in August? I was in DC. That's when the person unfortunately crashed into me, made a bad life choice. And the next day I was in a hotel and I made a live video, which I had made a live video not long before I left California, stating that I was going to file a 42 USC 1983. And what we've learned is that if you seek to take them to federal court, they really clamp down and start using the things that they're supposed to use to protect people as a means to deny you due process things like the PC 1368. And if you're able to prove that they're willfully, intentionally denying you justice, rather than say, for example, there's an attorney involved in this, and he's consistently suborned perjury with his client to the court. Him being an officer of the court means that is fraud on the court. Fraud on the court is not discharged when myself or you, as a plaintiff or litigant, respondent, whatever, that's when it's an officer of the court, a judge, an attorney, a clerk, because that's an attack on the machinery of justice itself. That action does harm to the machinery. It impacts the machinery. Where people like yourself or I, who may be under oath and commit perjury, is not acceptable. It should be punished under penalty of perjury. But when it is an officer of the court, it is an attack on the machinery of justice, and it vitiates everything relative to that fraud on the court. So one would think that they would be welcoming of proof positive evidence of officers of the court discharging such an abhorrent action against justice. So fraud on the court is an attack on justice. It's an attack on the machinery. So when officers of the court are not only neglecting to hold those accountable, but retaliating against people who are bringing forward proof positive evidence of fraud on the court, that in itself is an affront to justice and an attack on the machinery itself. If you or I do something, very rarely would that have any impact. But if an arbiter, if an attorney, a clerk, if they abuse a duty, a justice, it breaks that machinery down. The wheel stops spinning. And so therefore it's supposed to be addressed properly, but instead, unfortunately, we are met with retaliation. Things like the PC 1368 abuse. It's a must and a shall. It's not where they have discretion to be like, oh, I'm going to do this or I'm going to do that. There's case law. There's controlling precedent. And on December 18th, 2024, 100%, there was a violation of due process and rights. And that violation of due process caused catastrophic harm that snowball effect, where it started off here and it turned into this big old snowball, right? Now, you heard that they're alleging that that was a violation of a CPO, and they kept trying to say as much throughout the proceedings. It was not just an error in the police report, because Deputy District Attorney Lauren Oga continued to say that during the proceedings. And the judicial arbiter, the officer of the court, the fact finder, the truth seeker, kept ignoring that. And I kept saying as much, like, hey, what's going on here? And on day one, Mark Bosnecker asked, where's the criminal history relative to this? Because if it's a CPO, there should be some, and there was none, because it was not a CPO. It was a defective TRO that stated on there as much, saying that this is not evidence of DV. But what's happening is if you come forward with something that they want silence, they will then weaponize civil restraining orders to silence you, much like they did to Deborah Dunham from, I think it was Treasury Winery, when she is said to have brought forward public information about a Napa County employee. My circumstance, it's relative to a Napa County employee. So when they seek to conceal, they will turn these weapons against people and violate due process and violate their oaths and their duty to secure and safeguard the guardrails of the machinery of justice. And therefore, their actions and conduct is an attack on the machinery of justice itself. And therefore, their rulings should be vitiated. and there should be an accountability, but it's an uphill battle. It's an uphill battle to get the California State Bar to intercede or to get the Commission for Judicial Performance to intercede. So litigants that are being devastated by the harm carried out by these individuals and their distasteful disregard for things as significant as mental competency, man. Do you guys realize what harm they can do with that? They can put people in institutions. And one of the people that they use has actually been fired from the Berkeley Police Department. And Melissa Kelly, that's the chief investigator for Allison Haley, the Napa County District Attorney. She was fired from the Berkeley Police Department for falsely predicating and trying to impose a 5150, which means somebody's a danger to themselves or other, and try to institutionalize that person because she was displeased with their behavior. But she was caught by other people that were there, and she was fired from the Berkeley Police Department. But Napa County picked her up and made her the chief investigator for domestic violence in the county of Napa. They have her take the stand as a qualified expert of all experts. She trains other people. And yet she, having been fired for lying to try to impose a 5150, much like the PC 1368, it violates your rights. They then put you in an institution and you're there against your will, potentially force medicated, potentially they can force anything they want on you in the proceedings with the PC 1368. And somebody who was fired from the Berkeley Police Department was then hired by the county of Napa, and they put that person on the stand as their expert witness to chill the constitutionally protected safeguards and rights of people. This person should be on a Brady list. So how is Allison Haley, the Napa County District Attorney, how are they not disclosing this to litigants? How is the Napa County Public Defenders not disclosing this to litigants? They are all willfully in the know and abusing the PC 1368. Say you, the litigant, says, hey, that's Melissa Kelly. She was fired from the Berkeley Police Department. She should be on a Brady list. This is a Brady violation. That's a Brady versus Maryland. They may say, pursuant to PC 1368, we want to declare a doubt. That's what's happened. We have the transcript. When people assert their rights, Pitch's motions, Marsden motions, they get retaliated against by this weaponization. The vexatious litigant, these are all tools that they use to just 100% shut people down who have pretty good darn evidence that there is something going on. A PC 1368, folks, they can lock you in an institution. And they did. They did. This gentleman who San Nguyen, an attorney, a taxpayer-funded attorney, used taxpayer dollars and the machinery of justice to take a gentleman, violate his rights and due process, and put him in Napa State Hospital under a PC 1368. We have the transcript where he was allowed by Mark Bosnecker to go to sidebar and declare a doubt. That's forbidden. It's forbidden because Wendell Coleman would then, how would the appellate court or the state Supreme Court, how would they be able to ascertain through a habeas corpus, which he was able to get out of Napa State Hospital with the habeas corpus. But San Nguyen violated his rights by going to a sidebar, declaring a doubt, and Mark Bosnecker, the judge, allowed it. Mark Bosnecker violated his rights as well, because Mark Bosnecker should have said, no, you must speak it into the record. Did you submit sufficient evidence, substantial sufficient evidence? I do not see it. I cannot allow this. I am the referee in this court. I am the fact finder, the truth finder. I have a duty and a responsibility as my oath. And Mark Bosnecker did no such thing. And he's done it consistently with other people, as have other arbiters. It is a weapon that they use in tandem with one another. The district attorney, the public defenders, this is what they do. Because if there's no record of what is said at the sidebar, then the rule for PC 1368 and an assertion of doubt is violated because you must speak it into the record. So they all know this. They're judges. These are judges and attorneys. They know what they're doing. This is not a what? What? Did we forget to do that? Did I do that? No. This is a willful and intentional act. It's an attack on the machinery of justice, the Constitution. It's a structural error that violates the rights of people who are seeking justice and redress. And when an arbiter and paid attorneys, both taxpayer funded and district attorneys, taxpayer funded, well paid, use the machinery of justice to harm people who they're supposed to protect, and they do so claiming to be a representation of the people, by the people, against the people, with the money and the taxpayer dollars afforded by the people. DC 1368 abuses should come to an end in the county of Napa. It has been consistent, it is a violation, and it is very harmful. That harm, they then weaponized against me further, cost me my business, and much more. And so therefore it's not a toothless tiger. It's not a meritless argument. And so I have appealed to the Fourth Circuit Court of Appeals in the Commonwealth of Virginia to assert the narrative and the merits of my argument that the harm was done to me while in the Commonwealth. That harm was discharged. The tort harm was aimed at me from state actors in California. And I asserted what's known as the Calder's effects test. And what that is a case from a petitioner in the state of California sued somebody in the state of Florida who wrote an article that was published in the National Enquirer, which was published in California. And the Californian asserted that they were harmed by that article written in Florida and was able to sue that individual in Florida, establishing what's known as the Calder effects test. So although these individuals discharged this in Napa, California, in the county, they did so. The harm was directed at me in the Commonwealth of Virginia, willfully, intentionally, and knowingly, as heard in the public records requests allocated recordings of the proceedings. These were public records requests and their own recordings. So it's not like they can say they're surreptitious or improper, as they like to get angry about. It's their own recordings, man. Like, and they were going off on me and anger. And well, why would you be angry at me for what you do on the record, the harm, the corruption, and then try to say that my argument lacks merit? And that's what they've been trying to do. With the help of their attorneys, they're trying to say, oh, no, this is a California thing. You got to bring this to the Northern District. But the attorney, Ryan J. Starks in Virginia, I was there to file documentation at the Eastern District of Virginia in Richmond, and I was parking my car and paying, and he was walking by, and I was like, hey, man, how you doing, brother? And he was saying, yeah, I know it's unfortunate. But he's like, you know what? Take this to California, man. This isn't proper here. The harm was done here. I didn't lose my job in California. I lost it in the Commonwealth of Virginia. And I can show what catastrophic harm that caused, and that 100% that transpired here as a result of their conduct. Their falsely predicated CPO that was a TRO from family law, therefore violating not only jurisdiction, but then they threatened over state lines for me to accept and demand under duress their CPO that was falsely predicated on a violation of a TRO with absolutely no contempt of court proceedings. That rule that I read to you guys, that 3600, if you violate it, they're supposed to have contempt proceedings. You can still go to jail. You can still be fined if you violated it. But remember mens rea, willful intent. And again, I'm not an attorney. I have ADA compliance issues. I have a qualified, legitimate disability, a communication disability. I've been denied needs-based attorney's fees in violation of Family Code 2030 mandates and been forced to weather all of these procedures without an attorney against somebody who has an attorney. Then they flip me this thing that gives conflicting information. And I've said as much from the outset. And they lied and said it was a CPO when there was no CPO. Then they falsely predicate this 6 months later when I'm in DC complaining to the DOJ about them. Très bizarre. When you seek to prefer federal action, this is how they respond, unfortunately. And it's an abuse of the machinery. I keep doing my best to just be reasonable, but it's like this is what I'm left to do. Is I've asked the California Supreme Court, I've asked the California Court of Appeals, and what they're doing is just like it's bizarre. So it'll be interesting to see. The California Supreme Court has accepted my documentation, and I'm not an attorney. I'm just a guy. I don't have an attorney. I've asked for an attorney. I'm entitled to an attorney under the statutory language of the law. I've been denied as much, pressed through multiple proceedings. Thank you for those of you who showed up and try to support. I humbly and I greatly appreciate you. And it really saddens me that many of the people that are doing this harm their parents, man. And they understand. Some of them have excuses that they don't understand the dynamics of what's transpired and what happened to my first wife's father. Many of you here on Facebook knew my first wife's father. You know the gentleman that I joined the Army with, that he and I were entered the buddy system. We joined together, and that he would deploy to Iraq. I deployed to Kosovo as a peacekeeper to stop people from, we arrested murderers, and he would go to Iraq to fight in combat, and then would joined the Riverside Police Department and retired as a sheriff, but would be part of the gang unit there, some kind of specialized gang unit in the Riverside County. And we, like I said, we were all friends. My buddy that I joined the Army with, he knew my first wife and my first wife's father and all these people. I don't know if he knew my first wife's father. He may have, but our friends that we'd go partied up. We were young and it's wild in San Diego and Mexico and Rosarito and Ensenada and all that. San Felipe, and we were just trying to have fun. But many a catastrophe would ensue, and it would lead to the unfortunate present circumstance. There's been loss of life. There's been human life taken. And the wanton disregard by the county of Napa and these people who would never in a million years allow their child to be placed in the harm that I've had to battle against. You know, I've battled all the way across the country, as I said I would. It's exhausting. And I'm left to do stuff like this. I don't want to do this stuff. There's other things I'd love to do. But I did make a promise to God when I got to Petersburg, Virginia, and I'm not in Petersburg. But when I got to Petersburg, I found a prayer house there. And I got on my knees and I made a commitment to God. And I've honored that duty. And I'm not a perfect person. I'm not the perfect Christian, but I'm not no pushover either. And I said that I would non-violently, peacefully assert my rights to protect my child. And that's all I've done. And people like Congressman Mike Thompson, a sitting U.S. congressman, tried to frame a peacekeeper, a sitting U.S. congressman who's running for position again, willfully, intentionally presented false narrative to slander and defame me with his staff, alleging they had been threatened. But I have all the evidence to refute that. I was recording everything when I went into those public places, man. I had a bad feeling, man, and I'm so glad that I did. That vigilance has afforded me the ability to walk into courtrooms and prepare transcripts to show that these people lie under oath, under penalty of perjury. They lie in documents, and it's harmful and it's consequential. It's defamatory. And so a combat veteran, Purple Heart recipient, lied to try to frame a peacekeeper who went and deployed with other infantrymen to working outside of our job description to go stop people from taking the lives of one another. And so for them to make me and try to frame me like the combat veterans who I deployed as a peacekeeper, my brothers would later deploy to combat operations, and they are combat veterans. And many didn't make it home, and many did make it home and weather the storm of life with physical or with mental and physical harm and scars. So for a decorated combat veteran, a sitting congressman, to use his position to try to make me out to be a threat, um, it's an affront to veteranism, to his duty and his title to the people. And I was concerned, but I'm glad that I had the wherewithal, the foresight to make sure I recorded everything when I went in there. And like I said, I think they thought I was just saying that from the outset, but I've been dropping those into affidavits of truth and having them notarized